Hello friends, today I will tell you about a very interesting case involving two senior officers of the CBI. This landmark judgment based on registration of FIR against government officers. The story is simple but has a long and complicated history in the courts. Let's understand it step by step. The case background is that two CBI officers, namely Vinod Kumar Pandey, who was a then CBI inspector, and Neeraj Kumar, who was a then joint director of CBI, were accused of misconduct. Two different people, Vijay Agarwal and Sheesh Ram Saini, filed two writ petitions in the Delhi High Court in year 2001 under Article 226 of the Constitution of India, read with Section 482 of the Code of Criminal Procedure 1973, seeking directions for registration of FIR against the above two officers on deputation to the CBI, namely Vinod Kumar Pandey and Neeraj Kumar, for committing offences under Sections 506, 341, 342 and 166 and Sections 218, 463, 465, 469, 166 and 120b of the Indian Penal Code 1860, as alleged in the writ petitions respectively. In other words, they requested that an FIR should be registered against these two officers for serious offences like abuse of power, wrongful confinement, threats, creating false records, and criminal conspiracy. The aforesaid two writ petitions were decided by the single judge of the High Court on 26th June 2006, but by separate orders passed in identical terms. Both the petitions were partly allowed and directions were issued to the Delhi police to register a case on the basis of the allegations contained in the complaint, dated 5th July 2001, lodged by Sheesh Ram Saini with Police Station Lodhi Colony, Delhi, and complaint dated 23rd February 2004, addressed to Commissioner of Police, Delhi, by Vijay Agarwal respectively, and to get the matter investigated by the special cell of the Delhi Police by an officer not below the rank of Assistant Commissioner of Police. Uninfluenced by the findings and the observations contained in the inquiry report dated 26th April 2005, conducted by the Joint Director CBI. The High Court even noted that documents were seized by CBI without following proper rules. Seizure memo was made one day late, and that one officer, Pandey, intimidated Vijay Agarwal to withdraw a complaint against Neeraj Kumar. The court said these actions were serious and not just small mistakes. In short, the writ petitions were partly allowed with the directions to register the FIR with the finding that prima facie cognizable offences are made out for investigation against the applicant officers. Aggrieved by the aforesaid judgment and order of the High Court dated 26th June 2006, both the officers of the CBI preferred separate letters patent appeal before the division bench of the High Court. The said letters patent appeals were dismissed on 13th March 2019 on the ground of maintainability. The two CBI officers were unhappy with this decision, so they filed appeals before Supreme Court of India. Made arguments in Supreme Court, the officer's lawyer argued that the complaints did not show any real cognizable offense. They said the High Court had no power to directly order registration of FIR. They also claimed that whatever they did was part of their official duty, so they should be protected by law. On the other side, complainants argued that the officers misused their power. The complaints clearly showed serious misconduct, and no one, not even CBI officers, is above the law. The Supreme Court studied everything and gave a balanced order and said that FIR must be registered because prima facie serious offences are made out. The investigation will not be done by the special cell, which usually handles terrorism, but by the Delhi police led by an officer of ACP rank or above. The old CBI inquiry report can be looked at but will not be treated as final. The investigation must be completed within 3 months. The two officers must cooperate with the police. No arrest or coercive action will be taken against them unless custodial interrogation is absolutely necessary. In this judgment, the Supreme Court made it clear that even CBI officers are not above the law. If there are allegations of misuse of power, they must be investigated. Justice must not only be done but also seen to be done, especially when those who usually investigate crimes themselves face allegations. So friends, this case shows us how the legal system works step by step from High Court to Supreme Court, and how even powerful officers can be investigated if complaints against them show serious misconduct. Friends, if you found this video useful, please do like, share and subscribe for more such legal stories explained in simple words. Thanks for watching.